Well, good morning. Thank you again for joining me on this video. Some weeks ago, we looked at dispute resolution and we talked about a number of issues. One of the things we touched on was errors and omission insurance. I want to pick up on that today and talk about some of the areas where errors and omission will not cover you and make sure you're aware of it. The first one is to understand that our errors and omission policy is something called a claims-made policy. What that means is that as soon as you sense there could be a problem, you need to notify errors and omission and have them open a file. Now, this doesn't mean that it will move ahead into litigation, and in fact, if nothing happens, there's no prejudicial problem against you for opening a file. But if down the road it does turn into a court issue, and it's proven that you knew about it and didn't notify errors and omission, they can and often will refuse coverage. Their philosophy is simple. They figure that during that interval, you may have said or done something that jeopardizes your position. It's a little bit like you see in the cop shows on television where they read them the Miranda Rights, and they say anything that you say can and will be used against you in a court of law. And once the defendant is asked to see his lawyer, they stop asking questions, and the first thing the lawyer says is, don't answer any questions, don't say anything. And the problem is that you may say something inadvertently that could be used, and because the errors and omission people are on the hook for not only your legal defense, but any settlement over and above $2,500, they want to make sure that you don't create any problem. It can create some problem for you because they may tell you once you open a file that they don't want you to talk to anybody, and that may include your clients. But you got to be very, very careful, and it's a claims-made policy. And that's why sometimes you may get correspondence, and on the top it says without prejudice. What that means is that you can't use that correspondence against the person who sent it in a court of law. So that's the first thing, claims-made policy. The second thing is property management. They won't cover problems that arise from property management. Now, when I say property management, I'm not talking about renting a unit for somebody. That's trading in real estate. It's trading in occupancy rather than ownership, but it's an interest in real estate. But sometimes you may be working with clients from out of town and you may sell them an investment property and they say, I'm new to this game, I don't know what's involved in being a landlord, and you say, well, you're not only that, but you're not local here, I'll look after it and I'll manage the property for you. And that's fine, and we understand that happening, but understand if there's something happens tied in with that property management, you're not going to be covered under errors and omission. So if you're doing that, you want to get a separate policy that covers property management. The third thing you need to understand is opinion of value or appraisal. Now, you from time to time give an opinion of value or you do an appraisal. And everybody's an appraiser, everybody has an opinion, and there's nothing to stop you from doing it. Some lenders require an AACI or a CRA or something for designation, but you can give a letter, and often you may give a letter because somebody wants to tie in with their income tax, or it's a spouse wants to buy out the other spouse, something like that. What you need to understand is, while you are covered for appraisals or opinion of value, you're not if they're used for financing purposes. And sometimes you just don't know. We had one time, and as far as the agent knew, it was for an innocent reason for establishing value, but it turned out that the person who received the opinion of value used it to arrange private financing, and it also turned out that there was on title a limiting factor that limited what property could be used for, and the buyer who bought the property was intending to use it for that specific purpose and could not. So there was a lawsuit involved, and it became very, very incumbent on us to prove that we didn't have any knowledge it was used for financing. So you may want to put on an opinion of value or on an appraisal that this is not to be used for financing purposes, because otherwise, as I say, errors and omission won't cover you. The last thing I want to mention is fraud. Now, you'll say, well, of course they wouldn't cover you for fraud. Well, actually, in our mortgage division, the errors and omission insurance there will cover fraud. But here in real estate, it will not. And of course, if you are knowingly involved in fraud, you're going to lose your license, may go to jail. The lawsuit may be the least of your concerns, and I certainly hope nobody does anything that's fraudulent. But you may inadvertently do something that's fraudulent. The participants may have an agenda that they don't tell you about. So you got to watch for certain things. If they want you to put something in then they don't want it in the agreement of purchase and sale, the chances are it's fraudulent. They may say, well, the seller is going to rebate the buyer $50,000 for renovation, upgrade, painting, and so on, but don't put that in the agreement of purchase and sale. What's probably happening is they're trying to arrange for a nothing down purchase, and you're involved. Or they may say, indicate that the purchaser is going to be living in the property when in fact he's not, and if a lender knew that, they wouldn't advance the funds because it's a rental rather than only occupancy. And if you know that, you're participating in that. I was in a cruise some years ago, not that long ago, just before COVID. I met a couple from Seattle, and I was talking to him about the meltdown in the U.S. in 2008 and asked him what he thought of that. He said, that was great. He said, I bought 2 or 3 properties. He said, the real estate agent I was working with told me they could arrange I would buy with nothing down. They just provided 2 agreements. One was the real price and one was an imagined price, and I was supposed to state that I was providing a deposit when I really wasn't. The old Oklahoma deal. We had that happen recently here. An agent had clients, and those clients were moving out of the area, and she referred it to an agent somewhere else, and said, now they won't be able to buy, they haven't got any money down, so they're going to be renting, but at some point in time you may be able to sell them something. Next thing she knew, they were buying a property. She asked them, how's that come about? And they said, well, the agent said, no problem, we'll just do 2 agreements of purchase and sale. That's fraud. That's mortgage fraud. Be very, very careful involved in anything that smells or looks suspicious. You don't want to be involved in fraud. You don't want to be involved in fraud as far as RICO is concerned, as far as the government is concerned, the law is concerned, and certainly as far as errors and omission are concerned. I hope that makes sense. Keep an eye out for this. Errors and omission insurance is a wonderful thing. It's first dollar legal defense, and your limited liability is $2,500 if there's a claim that's successful against you. But be careful that you don't fall into some of these pitfalls. Hope that makes sense. Thank you for sharing the time, and I look forward to talking to you again next week.